capable of causing explosions, damage like any other bombs, which aim is to cause destructions. This directive, like other directive, is a manifestation of anarchy-minded of the defendant, which is set out to express through his Biafra radio, which he claimed to be the founder and director. The defendant, through the Radio Biafra platform, carried out so many terrorist attacks, which led to the destruction of lives and property in Nigeria. The defendant is not only confirmed to local terrorists, but I hold without hesitation that he is an international terrorist, flowing from his threats to attack British High Commission and American Embassy, as well as his incitement against the British High Commissioner to Nigeria at the time, Catherine Lyons, a known woman of peace. In a broadcast of 21st October 2020, the defendant stated thus, and I quote, "Radio Biafra is now in the hand of the enemy of our freedom. I don't know how much they paid for it, but I know that Britain spent about 4.8 billion a few days ago to support what is happening. That is what they have done. I told you a while back that Britain was now in charge of what is happening in the zoo, and you thought that it was a joke. They have now come with their clampdown, but they are not going to succeed. Radio Biafra belongs to us, but why is it not playing our program right now?" Unquote. The defendant also stated, "I am telling you people to go to the bush. Wherever you see a military convoy, you attack them. Whenever you see a police convoy, attack them. They are human beings, and they also bleed. Any person with a police uniform or any army uniform is your enemy." Around 57 minutes mark into that video, the defendant directed his threat at Catherine Lyons, the British High Commissioner. He stated, and I quote, "They came to Tinubu. It is a surprise that after the British Commissioner came to Tinubu, they opened fire on protesters in Lagos. You should not be shocked. The woman is demon, a big demon. She too will go come repentance." Around 1 hour, 8 minutes, 35 second mark, the defendant also stated, and I quote, the same thing that Britain did to Biafra in what they are doing to us now, media blackout. Do you want the world to report this issue? Take over the British High Commission. That is all. Take over the consulate in Lagos. Take over the one in Abuja. Every newspaper in the world will report it in the morning. If you march on the British High Commission in morning, front pages in the world will carry it, and the world will ask why is British Commission in Abuja and Lagos under occupation by Nigerian youth. Then it is over. I'm giving you a master strategy of how you should be done. In a formation of 3 lines, there is something I want you to do. I'm announcing it on air so you understand. People should go to every weather shop around you. You know those who build bullet-proof door. I don't care how much it costs. We will pay. Everybody who is a welder, who builds bulletproof, people should take those doors and put nails in front of them and stand in front of protesters so that bullets cannot go through. Push the door, get the weapons, and deal with them. When you are marching to the British High Commission tomorrow, form 3 lines. They will have the army surrounding them. They will send a cable to London that British High Commission in Lagos is under attack. They will be forced to release it. Then the whole world will know that a revolution is going on. Without that, you cannot succeed, unquote. Even recently, in this courtroom, on the 7th day of November 2025, when the matter came up before this court, the court wondered the kind of malice and hatred which the defendant had for Britain. I will produce same parts of the proceedings of that day hereunto. Defendant, he says, there are issues at play which my Lord has not able to overcome, which even the prosecution has not even attempted to overcome. My Lord, are you asking me to go into the doors to defend myself on a non-existing law? If you can state that for the record, my Lord, I will be most grateful that you are going to try me or ask me to enter my defense where no law exists. Because if that is the position, my Lord, that means that the outcome of very trial is predetermined. A man of my station and caliber cannot be tried without any valid law. It is impossible, my Lord. I will tell you why. This was the case. This very case is bigger than this court. The case of mine started in 1957, when some brave men and women in this very country dared to ask the British to leave. The funniest thing is that all of them that pioneered that very bigger than this court, they all went to jail and were killed. Court, I'm learning this now. Then ask the British to leave. Defendants, yes, in 1957, Dr. Anthony Nao moved a motion at the House in Lagos, asking the white men to go and leave us alone. From that day, trouble started. Even before then, the like of Abat Macaulay was jailed, honorable men that fought for the indignity of the black race because they want me convicted. They told me so. Absolutely, my Lord. Absolutely, 100%. They told me. They said, I will come to court to see, to hear your case. When you take your plea, when persecution opens, then their case, when prosecution opens their case, when you start your cross-examination, when they refuse your no-case submission, I am telling you what happened a year and a half ago when you file your no-case submission and is rejected. You will not go into trial. You will be there during the verdict. You will be there during conviction. The court now responded. Let me just clarify this. It is also on record. You said that the British said that 1 year and a half ago that I was not the one presiding here. I want to say this, that I know my brother too, that was ascertain it will not get into that level of having anything to do, anything, because the way you are putting it. I want to say this. I do not have any relationship with the British. I have come here to do justice. I reiterate. Can you commence your defense so that if you commence today, I can extend time for you because your time has ended today. For the U.S. Embassy, it would have been attacked if not for the closure as a result of the protest. The defendant at about 2 hours, 24 minutes, 50 seconds, mark of the video of 24th day of October 2020 broadcast in Exhibit PWW stated, American embassy is shut down. Why won't they shut down? People are protesting. This statement regarding the embassy of United States of America is quite loaded. The statement could mean several things, none which are palatable or peaceful. What exactly does the defendant mean by the American embassy is shut down? Was he trying to attack the embassy if it has not shut down as a result of protest, or incite others to do same, as he did in British embassy? The inference to be drawn from the statement is that the defendant meant to do harm to the embassy of the United States by attacking or invading the embassy. Under international law, the premises of an embassy or high commission of a foreign nation is deemed inviolable. That means that even though the land belongs to host country, it cannot invade such premises. See Article 22 of Vienna Convention on Diplomatic Relationship, Article 22 of Vienna Convention on Diplomatic Relations, 1961. It provides thus: the premises of missions shall be inviolable. The agent of the receiving state may not enter them, except with the consent of the head of the mission. 2. The receiving state is under special duty to take all appropriate steps to protect the premises of the mission against any intrusion or damage, and to prevent any disturbance of the peace of the mission or impairment of its dignity. 3. The premises of the mission, their furnishings and other properties thereon, and the means of transport of the mission shall be immune from search, requisitions, attachment, or execution, unquote. Thus, from the above, it can be said that the defendant incited for people to invade British High Commission and his threat against British High Commissioner Catherine Lyons and American Embassy is an act of international terrorism. This is the purpose of Section 3 of the Terrorism Prevention Amendment Act 2013, which provides, and I quote, any person who intentionally murder, kidnap, commits other attacks on persons or liberty of an international protected persons, B, carries out violent attack on official premises, private accommodation, or means of transport of an international protected person in a manner likely to endanger his person or liberty. C, threatening to commit any such attack, commit an offense, and is liable on conviction to life imprisonment. The High Commissioner is an international protected person, being the representative of the British government in Nigeria, as well as other staff of High Commission and Embassy of the United States of America, leaving the defendant to continue his terrorist activity who have led to an international incident involving Nigeria and other foreign nations who are good partners with Nigeria. The question to ask again is whether bombing or attacking embassies of high commissions constitutes an act consistent with agitation for self-determination. Again, the answer is no. All these acts goes to show that the criminal tendency of the defendant, as well as show concrete proof of his terrorist acts. Therefore, I hold without hesitation that the prosecution as successfully established can cease against the defendant. Consequently, he is hereby convicted of count 6 of the charge. With respect to count 7 of the charge, the defendant is charged with importing into Nigeria and keeping in Ubuluzo in Ihiala, local government of Anambra State, within jurisdiction of this honorable court, a radio transmitter known as Tram 50L, concealed in a container of used household items which he declared as used household items thereby committing an offense contrary to Section 47(2)(a) of Custom and Excise Management Act, Cap C-45, Laws of the Federation of Nigeria, 2004. The dispute as to which law provides for the offense in Count 7 has been conclusively decided by the Supreme Court. In case of Federal Republic of Nigeria versus Kanu, Supra, where my Lord M.L. Garba, JSC, while reading the lead judgment, said, and I quote, "A calm reading of the details of the facts stated as constituting the offense mentioned or named therein would clearly and undoubtedly reveal that it deals with the offense punishable under the provision of Section 47(2)(a) of the Custom, Excise and Management Act, Cap C-45, Laws of Federation of Nigeria, 2004, which provides as follows: 47(2). If a person A imports or causes to be imported any goods concealed in a container holding goods of different descriptions, or he shall be sentenced to imprisonment for 5 years without the option of fine. It follows, in the above circumstances, that the mention of the Criminal Code Act as being Chapter C-45 or Chapter C-45 in Laws of Federation of Nigeria, 2004, is a mere mistake in place of correct law. The Customs and Excise Management Act, under which the facts alleged to constitute an offense in Count 15, is punished and punishable. The offense in Count 15 is consequently recognizable and grounded in an extant existing law in Nigeria in which it was defined and described, unquote. Thus, the court will follow the decision of the Supreme Court and decide Count 7 based on Section 47 of the Custom and Excise Management Act. The ingredients of the offense are: the defendant must have imported or caused to be imported goods concealed in a container. 2, the imported concealed goods must have been of a different descriptions. The evidence led by the prosecution through PW4 is that the defendant imported into Nigeria a radio transmitter known as Tram 550L concealed in container which contain used household items which he described as such. PW4 stated that indeed the Department of State Service had tracked the transmitter of Radio Biafra to a compound in Umuluzino in Ihiala, local government of Anambra State, belonging to one Benjamin Madubulu. The officer secured a search warrant, exhibit PWT, and proceeded to the compound where they recovered the container. Prior to going to the scene, PW4 testified that he watched a video of the defendant inspecting the container and the transmitter with Benjamin Modubugu. The court visited where the container was kept in the custody of the DSS, and same was admitted in evidence in the presence of the defendant as exhibit PWY, and he did not object to same. The container itself contains several household items which appear to be covered for the transmitter concealed in it. The prosecution has led evidence to show that the transmitter was smuggled into the country without same being declared to custom. That the cover of the household item was used to disguise its true content. The surrounding facts also show that the purpose for which the defendant intended to use the transmitter was to broadcast program on Radio Biafra, and this makes it conceal the transmitter. This is also not. There is also no evidence that Radio Biafra is registered with the Nigeria Broadcasting Commission as stated by PW4. Thus, it is safe to conclude that the concealment of transmitter is in furtherance of the illegal operation of Radio Biafra by the defendants. The defendants, as a consequence of resting his case on the prosecution, did not call any witness to rebut the evidence of the prosecution, neither did he lead any evidence to counter the evidence of the prosecution. There is no evidence before this court stating the transmitter was lawfully imported into Nigeria. The defendants had the duty to present evidence and fact to rebut the allegation made against him. But he failed and deliberately refused to do so. The court is therefore bound to believe the evidence of the prosecution. Consequently, the court hereby convicts the defendant of count 7 of the charge. I must say here that defendants have always claimed to be a freedom fighter. He is only seeking justice for his people. Indeed, this is known in law as the right to self-determination. The right to self-determination is a political right recognized in several international instruments. Article 1 of the International Convention on Civil and Political Rights, 1966, provides, and I quote, "All people have the right of self-determination. By virtue of that right, they freely determine their political status and freely pursue their economic, social, and cultural developments." Unquote. The right to self-determination also entails the right of a group of people to form their political entity or their own governments. Article 20 of the African Charter on Women and People's Rights also provides, and I quote, "All people shall have the right to existence. They shall have the unquestionable and inalienable right to self-determination. They shall freely determine their political status and shall pursue their economic and social development according to the policy they have freely chosen." 2. Colonized or oppressed people shall have the right to free themselves from the bond of domination by resorting to any means recognized by the international community. 3. All people shall have the right to the assistance of the state parties to the present charter in their liberation struggle against foreign domination, be it political, economic, or cultural. Unquote. Nigeria has domesticated the African Charter, which is known as the African Charter on Women and People's Rights, Ratification and Enforcement Rights, which means the provisions of the Charter are enforceable in Nigeria, provided they do not conflict with the clear provision of the Constitution of the Federal Republic of Nigeria 1999 as amended. Section 2(1) of the Constitution of the Federal Republic of Nigeria 1999 as amended makes it clear that Nigeria is an indivisible state, which means there is no room for divisions. The said section provides, and I quote, "Nigeria is one indivisible, indissoluble sovereign state to be known by the name Federal Republic of Nigeria," unquote. This means that anyone agitating for a breakup of the Federation of Nigeria is going against the Constitution. However, any person agitating for self-determination can do so through the National Assembly seeking for amendments of the Constitution regarding the indivisibility of Nigeria and to reflect the recognition of the agitating states. It is after this that the procedure can be said to be completed, but not excluding referendum. Any self-determination not done in accordance with the Constitution and laws of the country will be illegal. The defendant is not only agitating for secession of the states of the Southeast, South, and some Middle Belt states. He is doing so using terrorism as a weapon. Terrorism has become a monster in the world today, and several groups have continued to use this weapon to form separate governments. In Nigeria, groups like Boko Haram, Lakurawa, IPOB have in recent years troubled Nigeria with terrorist activities. This terror group, by their activities, has denied innocent people the enjoyment of their fundamental rights. The action of the defendant and his terrorist organization have led to the bloodshed of innocent citizens, as well as security personnel who were going about their legitimate duty. His incitement through the broadcast on Radio Biafra, as well as the social media platform of the group, has led to the destruction of lives and property, as well as affect the daily life of his people of Southeast. The defendant did not only threaten the government of Nigeria, but his own people. This is seen in a broadcast while addressing the death of one of the commanders of IPOB, named Ikozo. The defendant on 25th day of April 2021 made a broadcast where he stated, and I quote, Ikozo was not killed on the battlefield, but was killed in his village in the middle of the night. Not on the battlefield, because of the battlefield, no army or police can defeat him. Ever since Eastern Security Network was launched, I have not seen anybody tell me that their life have not improved since it was launched. Around 21 minutes marked, the defendant stated, vengeance is a monster of appetite, forever blood-tasty, never filled. Ikozo is in heaven. He is going to be revenged, and by God, he will be revenged. All those who had hand in Ikozo death are all dead. People walking, all of them. He also stated that Ikozo will be mourned in a special way, just like how the Oba of Benin is buried, with human heads. That they said Ikozo is more than an Oba. Thank you. There is no doubt that this is contained in the broadcast. The defendant's statement was corroborated by PW4, who stated that upon the arrest of one of the IPOB commander named as Onye Army, he informed them that they were only to get 30 heads of women out of 2,000 heads of, as ordered by the defendant. This court is aware that the said Onye Army was not caught as a witness in this case, and this may affect the probative value of his evidence. However, the evidence being used, this evidence is being used as corroboration to the statement made by the defendant himself, admitted by the statements of, and is admitted as a defendant for that purpose. Corroboration refers to supporting or additional piece of evidence that supports another evidence. See Ogunbayo and the state citation supplied, where the Supreme Court held, and I quote, corroboration having been held not to be a technical terms of all, means no more than evidence tending to confirm, support, and strengthen other evidence sought to be corroborated. This evidence is to corroborate the evidence, the statement of the defendants. I must say here that the prosecution witnesses were consistent and calm in the giving of the evidence. Their calm demeanor, despite provocative questions under cross-examination, shows them to be witness of truth. I carefully observed them, and the only conclusion to reach is that they are witness of truth. And this court readily believed them. The defendants, on the other side, from its attitude in court, was truly very cocky, arrogant. He even stated that no court can convict him. This is a direct affront on the power of the court, which this court will not take for granted, but will do justice. It is interesting to note that the defendant, who claimed to be a freedom fighter, has even caused more harm to his own people, who are predominantly Christian faiths. Can this be said to be agitation for self-determination? Not at all. Agitation for self-determination cannot be to the detriment or to be detrimental to people who are supposed to be beneficiary of that self-determination. The usual sit-at-home order primarily affects his own people of the Southeast. The killing of people who disobeyed the order are his own people. Ordering of closure of churches and schools as well as markets also affects his own people. They are unable to trade, go to school, farm, even worship on such days. The threats of violence and death have prevented these people from going about their legitimate businesses. Are these acts of the defendants consistent with the agitation for self-determination? The answer is in the negative once again. The defendant was not elected by anybody, also cannot dictate for the people of Southeast, especially through intimidation and threats of violence. He is a terrorist. He must be treated as such. In final analysis, the prosecution has successfully established the 7-count charge against the defendant beyond reasonable doubt. Consequently, he is convicted on all the 7 counts. By the time the next just 30 minutes I go to the chambers, anybody is free to come and get a certified 2 copy of the judgment.
As the court pleases,
may I get to the chambers, the next 30 minutes, it will be signed.
Thank you, my lord. May I invite your lordship's attention to the title of this case. It is Federal Republic of Nigeria versus Nnamdi Kanu.
I'm coming, sir.
Lord, the people, 200 million people of Federal Republic of Nigeria have brought Nnamdi Kanu before this court for acts of terrorism. And my Lord, in the last few weeks or last few days, Nigeria has been a season of victims of victims of terrorism. But my Lord, this afternoon, this honorable court delivered its judgment in which the convict Nnamdi Kanu was found guilty and convicted of offenses under Terrorism Prevention and Prohibition Act. He has accordingly been convicted and it is now to be sentenced. My Lord, the prosecutor has a duty to invite your lordship's attention to a few points that will guide your lordship in the sentencing. My Lord, by the judgment just delivered, this court has again affirmed the long-standing principle that whenever Nigeria as a nation is confronted with moments, actions, and events that pose grave danger to its existence, independence, and unity, the judiciary stands firm at the stabilizing force of the country, guided by the wisdom, courage, and integrity of judges who serve within that arm of government. Terrorism, my Lord, remains one of the gravest threats to humanity. It is among the most devastating of atrocities in human history. As the leader of the proscribed indigenous people of Biafra, the convict, through his broadcast on Radio Biafra and through the group Armed Wing, the Eastern Security Network, repeatedly attacked Nigeria and took active steps to desegregate the country. By the conviction of Nnamdi Kanu for acts of terrorism, it is clear that justice has been served to the thousands of innocent Nigerians who lost their lives as a result of the inciting broadcast and violent activities of Eastern Security Network. The blood of those who have died cries to heaven, and God in his mercy has given them justice. Justice has honored their cry. the families of more than 75 security officers who were murdered in the service of their fatherland will now find some comfort in this conviction. Those whose relatives were brutally killed and buried with Ikonso of the order of the convict here have not died in vain, because justice has been done. My Lord, the record before this court are replete with the losses suffered by citizens of Nigeria residing in the interstates of the Federation, citizens who, through no fault of their own, were forced to live in fear, had their businesses destroyed, and were reduced to paupers as a result of sit-at-home orders issued by the convict and violently enforced by the commanders of the ESN. Justice has today set them free from oppression and economic strangulation caused by the terrorist activities of the convict. The convict now knows that the law is greater than any individual. Therefore, justice has been done to him too, and that Nigeria has both the power and the capacity to punish anyone who, through deliberate, reckless acts of terrorism, seeks to divide the country by attempting to create the so-called Republic of Biafra by force out of the Federal Republic of Nigeria. My Lord, consequent upon the conviction, as nothing further remains but the lawful imposition of sentence, the punishment prescribed for the offenses in counts 1, 2, 4, 5, and 6 is death penalty. Pursuant to Section 1(2)(h) of the Terrorism Prevention Amendment Act 2013, my Lord, with all sense of humility, I say, sir, as a prosecutor, that this court has no discretion in that regard, and that the only sentence that your Lordship will impose for counts 1, 2, 4, 5, and 6 is death sentence. This court has the power to do so, and with respect must do so. The language of the act is clear, and the court is urged to apply it strictly without deviation. For the offense under count 3, relating to membership of IPOB, a proscribed terrorist organization, the punishment is imprisonment for a term of not less than 20 years, in accordance with Section 16(3) of the Terrorism Prevention Amendment Act 2013. We urge your Lordship, in accordance to death sentence, to also pronounce and impose the sentence as prescribed by law, having found him guilty and convicted. For the offense under count 7, the punishment is 5 years imprisonment without the option of a fine, pursuant to Section 46 and 47 of the Custom and Excise Management Act, Cap C 45 Laws of Federation. In sentencing, this honorable court is obliged to consider the nature and gravity of the acts of terrorism committed by the convict. It was against, the acts of terrorism were against innocent Nigerians who resides in the southeastern states. It is also a terrorism act against Nigeria, whereby nobody felt safe and secure in Nigeria, having regards to the activities of IPOB and ESN. The court is urged to note that the company has shown neither remorse nor penitence for the innocent Nigerians who died as a result of his directives and incitements. He has demonstrated no respect for the administration of justice. His conduct, even within the court, has been marked by arrogance and a heart far removed from humility. When he was going out, he looked at me and said, God will bless me. He won't say God will punish me. He said, God will bless me. And I say, amen. Because I'm a blessed man. It is not him, a convict, who can now put a curse on me. He cannot do that. So in any event, my Lord, I'm not being personal, but I want to assure you that somebody in that position ought to show some penitence, ought to show some remorse, ought to throw away arrogance and self-serving attitudes. The court is further urged to take judicial notice of the fact that the convict established Radio Biafra, a broadcasting platform operating on several digital channels, including mobile radio, Twitter, YouTube, Facebook, WhatsApp, blogs, and Instagram. It is a station with global reach. Evidence before the court, my Lord, shows that when the convict was arrested on 15 October 2015 at the Tulip Hotel in Lagos, he was found in possession of broadcasting equipment. The conduct of the defendant through online publications, live broadcasts, and social media communications constitute acts of incitement, encouragement, and provocation of terrorism as defined under the Act. It is the view of the prosecution, Lord, that without the instrumentality of the internet and social media platforms, the magnitude of destruction, division, and human losses recorded in southeastern states of Nigeria, including Lagos, would not have reached the level it attained. The digital platform becomes tools in the hand of the convict, tools of radicalism, ethnic hostility, and incitement to terror. Their amplified reach resulted in a coordinated transnational militarism or militarization of violence and destructions of public property across several states of Nigeria. The court has both the power and the duty to restrict further access to digital media through which the offenses were committed by making orders that prevent the commission of similar or related offenses, including forfeiture, confiscation, or restrictions of the means used to commit the act of terrorism. As a form of preventive control, the prosecution praised this honorable court to impose restriction on the convict's access to digital devices, online accounts, or internet facilities. In other words, my Lord, anywhere he may be kept until his execution in obedience to the sentencing, if he has access to these devices, and they are cheap and easy and available everywhere in Nigeria, there will continue to be broadcast. Maybe he will claim he was not the one. At the moment, if you open to YouTube, you see a lot of rascals talking about the proceedings of the court, trying to twist and misread and mislead the people with what happened in court. So we're asking that your lordship should restrict him from having access to these devices. This honorable court, my lord, has the statutory power to prevent convicts from further committing offenses by making orders for the forfeiture, confiscation, and restriction by any means used for communication. We therefore pray that the court to order the forfeiture of all the broadcasting equipment, digital devices, and all electronic materials seized from the convict and currently in the custody of the Department of State Security, State Service. In particular, the radio transmitter, Trans 50L, unlawfully imported into the country, should be forfeited to the federal government of Nigeria. My Lord, we want to say, sir, with all respect, that it might be argued that access to information access to digital devices may be argued within the constitutional rights, but it's not absolute. So therefore, sir, if your lordships want to order his restriction, your lordship may give him a right to acquire any, but with the permission, with the authority of National Security Advisor and the Controller General of the correctional facility that he may be put. Therefore, my lord, it's not an absolute or free right for him to begin to acquire those digital devices that may encourage him to reenact or to begin to commit the same or similar offense under his right to freedom of speech. So we are saying, my lord, that your lordship should restrict it. My lord, considering that the company has to be in a custodial facility, we are asking your lordship to direct that for the safety of the convict, for his safety, for his security, and for the protection of his life until your sentence is executed, I respectfully, sir, as prosecutor, plead with your lordship to direct that he be kept in the safest custodial center anywhere in Nigeria, because his safety is very important. Your lordship need to take judicial notice of what happened when Simon Ekpa was sentenced in Finland. There are lots and lots and lots and lots of talks and talks. The convict has enemies. He has friends. But no one can say the volume or the number of his enemies who may want to eliminate him. So we are asking, my lord, that your lordship order the government of the Federal Republic of Nigeria to keep him in the safest custodial center anywhere in Nigeria. You know, and if I may say with all sincerity, I am not too sure that Kuje, where there have been jailbreaks, will be the ideal place. So I'm urging your lordship with all sense of responsibility to preserve his life until he answers his sentence. So I thank your lordship, and I pray that the incidents of terrorism will cease from Nigeria, from north to east, to northwest, to north central, and as we see, may God spare Nigeria of disintegration. I want to thank you. I want to appreciate you on behalf of my colleague, Adebayo Ojo, and Suraj Saida. We are grateful to your lordship for a well-researched, a well-reasoned, and a courageous judgment. Thank you, my lord.
There is no doubt that the convict has waived his right to be present through his unruly attitude, the habitual unruly attitude to be in court when the judgment was read. But we must still give him opportunity to hear one or two things from him, but not personal through his person. Since his consultant is here and the offense has to do with death sentence, I will call his consultant, that was his lawyer before he converted him to consultant, if he has any allocutors to make on his behalf. Mr. Ejimako, do you have any allocutors to make on his behalf?
My lord, being an officer in this temple of justice and not being properly dressed and not being his counsel of record, I will yield this very task to Honorable Obinna Agocha, who is better qualified than me, being the member of House of Representatives who represents Mazi Nnamdi Kanu.
It's okay. Honorable, let me have your full name and restrict yourself to allocutors. Allocutors is what we mitigate the sentence. Is our brother. Let us hear you. You tell us your name. We can't, because of your ruling behavior, deprive him of allocutors. Can I hear from you?
Thank you, my Lord. My name is Right Honorable Obi Agocha. I represent the good people of Iguano, Umuahia North and Umuahia South Federal Constituency in the 10th National Assembly. My Lord, I am the direct representative of Mazi Nnamdi Kanu. That's why you see me here almost every time, showing presence and also showing solidarity with him. The matter has come to a closure for now. I'm not his lawyer. I wouldn't know whether they will seek appeal. But for now, my Lord, he's my brother. He's my friend. I went to school with him. We attended primary and secondary school together, though he was my junior. But it is my responsibility and obligation as a member of the National Assembly to represent him as well. My Lord, I plead for mercy, I plead for clemency, and I appeal for peace and for stability of not just the Southeast, but as well as Nigeria. Like the prosecutor said, Nigeria is bleeding over the last few days, and we must bring some of these issues to bear and to understand how to find common solutions to our common problem of terrorism. I also wish to appeal to the prosecution team that it has been done to Mazi Nnamdi Kanu. The other people out there also doing more worse than him.
Please,
sorry, sir.
I asked for a locutor.
Yes, sir.
Please, don't
so, I apologize, sir. So I want the court to take judicial notice of that this trial has gone on for almost 10 years. Mazi Kanu is almost 56 or 57 years old now. He has been absent in his family life, his children, his community, his family. So I plead for the Lord to show mercy, to temper justice with mercy. And as we move forward, it shall be great for our country. Thank you very much for the opportunity. I'm a friend of the court, having come from the other side of the government. So thank you for giving me the opportunity to address the court. Thank you, sir.
Thank you. I will consider all this, and I will rise and come back by 10 minutes to 4. You may go and come back 10 minutes to 4 for the sentencing. I will rise and come back.
Just witnessed the live broadcast of played out at the Federal High Court's Justice James Omotosho's court, where Mazi Nnamdi Kanu, the leader of the proscribed indigenous people of Biafra, has now been convicted on all 7-count charge bordering around majorly terrorism. And you saw the allocutors by both the prosecuting and, well, he defended himself on this particular one, but his former counsel was given an opportunity for an allocutors, which he yielded to the member representing him in the National Assembly. some of the things requested by the prosecuting counsel is that to the effect of being convicted on count 1, 2, 4, 5, and 6, Nnamdi Kanu should pay the death penalty. And on count 3, 20 years. On count 7, 5 years. Body's friend, his representative, has sought for clemency. He's not sure whether this will be appealed. So that's what has been playing out in terms of proceedings at the Federal High Court, Abuja, under Justice James Omotosho, on this 7-count charge preferred against Mazi Nnamdi Kanu. The case has lasted for almost 5 to 10 years. The judge said he's taking a break, and when he returns, it will be time to make pronouncement in terms of sentencing. So you've been watching this live broadcast coming to you from Channels Television, live from the courtroom at the Federal High Court in Abuja. We'll now return to our regular programming, and I'll bring you back to the moment when the judgment will be read by the Honorable Judge. Stay with us.
This is a live Channels Television event. Our website, Channels TV.
It's a fast beat, unpredictable and full of surprises. The unforgettable moments, unprecedented passion. The victories and defeats in the world of sports makes it engaging. Fasten your seatbelts as we take you through every update in the news and on our shows. We define the moments of true sports. Join us.
Welcome back to Hard Copy right here on Channels Television. If you just joined us, we're discussing the concept of a Christian genocide, especially in Plateau State. And joining us is a lawmaker, or former lawmaker, representing Jos East and Jos South.
A former lawmaker that had judicial genocide that removed all of us from the office. You know what it means to remove 7 federal legislators and 16 House of Assembly members unjustly.
Mr. Bagos, who removed
So who removed? Definitely the court removal. So it was a judicial genocide. Well, let's go back to your by the way, yeah.
But you're coming back, aren't you?
Yeah, by the grace of God.
Since you opened the door.
By the grace of God.
You opened this door. Is it true that you're running for Senate?
Absolutely, by the grace of God. We're running for
What party?
Senate.
I saw an article from the youth from Jos East.
No, Jos South.
Jos South.
My own village.
Yes, your hometown, where they were saying they wanted you to leave the PDP for your political future.
Yeah, well,
they say you should join the APC. Are you going to?
Even in the PDP today, who is going to sign my form? Is it the Abdul Rahman led NWC, or is it the Magun led NWC? I can tell you, Plateau is PDP, yes. We are so proud of PDP. But then you cannot win election on sentiments. That's the truth. We must tell her we cannot. So as of today, unless before 2027 election, the PDP put its house in order, but definitely every politician will look for an alternative. So there is a time as a politician you have to listen to the voice of your people and know what the true situation is all about. But like I said, politics is all about ideology. So whatsoever ideology of my ideology, the ideology of my people, goes in line with the ideology of any political party, and that's what my people accept. We run.
Don't you have a time frame before it becomes too late for you to decide?
Yeah, well,
where you're going to run on.
But then you know that the Constitution and whatever gives waiver for whoever wants. So we're still consulting. But we have at the same time, we have a leader who is a governor, and we're so much in love with him. We're waiting to hear what he intends to do, because wheresoever he is, we'll definitely support him. But I can tell you, with the political ideology or loyalty to politics this time around is evolving that loyalty to politics is to a candidate, not to a party. You know that. In as much as party is supreme, the supremacy of a party depends on
Let me bring in the the mic. I guess we've seen and heard it all from the courtroom where Nnamdi Kanu is being tried and sentenced, reeled out. As you can see, that the judge had ultimately convicted Nnamdi Kanu of terrorism charges. Okay, that is the situation of things we are bringing to you live on our report today. It's quite unfortunate that the judges in Nigeria are relying not on the law or the constitution, but on the body language of political juggernauts, political players. So Nigerian judicial or justice system is highly politicized. From the judgment as a layman, you know, they relied more on the prosecution aspect of the trial and not really the defendant's aspect of it. Like, you know, in law, it's said and believed that someone is not yet a criminal except convicted, is deemed innocent. So it is now the work of the prosecutor to prove. But in the case of Nnamdi Kanu, reverse is the case. It is now as though, because from the readout of the entire sentencing and judgment, it is clear that Nnamdi Kanu had long been convicted from the point of view of so many people who are watching from different platforms, you know, and also from your own observation, you can see that the judge is skipping and stammering through the judgment, reading the judgment. Okay, while reading the judgment, he had been stammering and skipping words, and people are asking if actually he was the one that wrote this judgment or someone handed those judgment to him. And someone have earlier predicted that this is what is going to turn out, that Nnamdi Kanu will definitely be tried and sentenced like a script already written. And that is what many have seen playing out today. So that is just it for now. I think they've gone on recess. When they come back again, we'll come back again to continue in the sentencing. He has just read out the judgment. From the judgment, it is clearly seen that Nnamdi Kanu is perhaps convicted, okay? Convicted of terrorism charges. Now, the sentencing is what will follow suit. So, while the judge is on a recess to come back any moment, we hope that when they come back, they'll read out the sentence that they are handing down over to Nnamdi Kanu. Okay, and what will happen afterwards? I believe Nnamdi Kanu is going to take it up. I believe this is not the final judgment. Okay, and it's unfortunate. Now let us go to some of the commentaries we have here already. We have Jeff Henry said that the man can't read. He's asking why the judge cannot read. Well, perhaps your assumption is as good as every other person's assumption that is handed over to him. Okay? The man is giving story, not judgment. And that is coming from Ifeanyi Obi. And then Nnamdi Honest Ike is saying that he lay curse on Nigeria and on Motosha. People are really very, very angry with this It's an emotional judgment for so many people. And what even baffles me is when they say it is the 250 million Nigerians that dragging Nnamdi Kanu to court. I beg, count me out of that 250 million. And I believe if people start counting themselves out, perhaps we have just a few people, not up to 100 or 200 persons, especially those of them from the ruling class in Nigeria today, that are the ones that drag him to court. I'm telling you honestly, because the Nigerian people are still struggling to survive insecurity as we have in Nigeria today. So, a lot of things we had today. Nnamdi, honestly, said, even the person reading, I wonder which school the person attended. Now, George, they talk about. So that is it. So we hope that the judge is going to convey back again while we wait. Let us browse through and see what is happening and other things that are trending that we can bring forward to your knowledge and to your notice as we continue in this update to inform you better. Okay? So, let us inform you like what we brought to you yesterday, that the church that was attacked by the terrorists, Fulani terrorists in church while they were live in church. That one still there. Those ones are no terrorists. Those ones are VIPs. Right, Nigeria. Eh? Hey, on one hand, because somebody was on the mic like this and speaking, he own terrorist charge big past the ones that are on the field killing Nigeria.